Hi guys, good evening. Welcome to another session of Company Law under the top MCQ series. So this is going to be the class number 6 for Company Law. Before that, we have conducted 5 sessions and I hope you have gone through it. And the MCQs that we are discussing here, they are based on the most important concepts, most important provisions of the company law, and many of the questions have already been asked. And believe me, you will be finding in the examination many questions from the discussions that we are having through this top MCQ series, right? So if you haven't gone through them, guys, please go through them, the important sessions. And if you are going through them, then guys, that's a perfect news for you because you are preparing well for the examination. So let's start the discussion without wasting time here. First of all, you know that we discussed the achievers question, and which is a homework question of the previous session. So the question that we had discussed in the previous session, the question was under section 68 subsection 3, which of the following is mandatorily required to be disclosed in the explanatory statement accompanying the notice for passing a special resolution for buyback? Options are details of previous year's audited financial statements, names of directors supporting the buyback, the class of shares or securities proposed to be purchased, list of shareholders eligible for the buyback, or SEBI's prior approval for the buyback. So even if you had not answered previously, guys, you can answer it right now in the chat box. And you know, those who give the right answer of this achievers question, their name is reflected in the next session. So right answer is option number C, that is the class of shares or securities proposed to be purchased. And here you can see Omkar has given the right answer, Omkar Jadhav. So congratulations, Omkar Jadhav, you have attempted the question correctly. And guys, if you also want to see your name in this achievers slide, so you know the rules that you have to participate in the achievers question, right? So in this session also, the last question will be the achievers question, and if you give the right answer, your name will be reflected in the next session, that is tomorrow. So give the answer and see your name here in the achievers slide. So let's start the today's agenda. Question number first is, as per section 173 subsection 1 of the Companies Act 2013, the first meeting of the board of directors must be held within how many days? Options are 30 days of the date of incorporation, 45 days of incorporation, 60 days of incorporation, 90 days of incorporation, or 120 days of incorporation. Guys, these kind of questions are asked in the examination. So yes, that is why we are practicing here, and these sessions are conducted so that you can gain confidence, right? You can enhance your knowledge, you can commit the mistakes, so you can make the revision. So all the things required for the examination you can get out of these sessions, provided you are consistent. So consistency is required from your side, guys. Rest, each and everything will be taken care of by me only. So Rohit is saying option number A. Right answer is option number A. Very well attempted, Rohit. So 30 days of the date of incorporation. So section 173 subsection 1 mandates that every company must convene its first board meeting within 30 days of incorporation. This requirement ensures that board becomes operational at an early stage to take key decisions such as appointment of officers, opening of bank accounts, etc. Right? Great. Moving on to question number second. Question number second is saying under section 173 subsection 1 of the Companies Act, the maximum gap allowed between two consecutive board meeting is, options are 90 days, 100 days, 110 days, 120 days, or 180 days. Guys, believe me, factual questions are asked from the Companies Act. Only 7 chapters you have to cover, which are mentioned in the notification, and this is one of the easiest component in the SEBI Grade A syllabus. This is the most easiest according to me, because nothing is going to be a change here. Everything is fixed here. You just need to cover the factual things, 7 chapters, and you are ready with the Companies Act. Yes, so let me know what is the right answer according to you. Even if you do not know the answer, guys, do make a guess based on your study, based on your reading, based on your preparation, based on your, you can say, logical things. Try to attempt it. What will maximum happen? The question will go wrong. That is why, right? This is the only thing that can happen, that your answer may go wrong, right? But guys, you will gain the confidence. If you commit the mistakes, even after committing the mistakes, we gain confidence, right? Okay, so Rohit is saying option number D. Option number D is the right answer. 180 days, right? So this is the right answer here. uh, it's not 180 days, it's option number D. Yes, 120 days, not 180 days, sorry. The option number D is the right answer. I was saying 180 days, so this is 120 days, right? So the act requires that a company must hold at least 4 board meetings every year, and importantly, not more than 120 days should elapse between 2 consecutive meetings. So yes, option number D is the right one. Question number third is, as per section 173, subsection third, the minimum notice period for calling a board meeting is, options are 3 days, 5 days, 7 days, 10 days, or 14 days. Yes, guys, tell me. If you refer the previous year paper, you will get to know that these kind of questions are asked in the examination. And I'm not saying a big thing, guys. In the examination, you would be observing that many questions from these discussions will be there in the examination. Some questions will be the direct question itself, right? This is my promise. This is what I can maximum tell you. Now, rest is your choice. If you want to continue the session, if you want to join the session or not, if you are consistent or not, that is completely up to you. The what is my responsibilities, I am fulfilling that, right? Yes, so tell me, the minimum notice period for calling a board meeting is, options are 3 days, 5 days, 7 days, 10 days, 14 days, but the right answer is option number C, that is 7 days. Yes, Rohit, you have attempted it correctly. So as per section 173 subsection 3 mandates that a board meeting must be convened by giving not less than 7 days notice in writing to every director at their registered address. Question number 4 is, a board meeting at a shorter notice for urgent businesses is valid only if all directors consent, the chairman approves, SEBI grant permission, the registrar is informed, or at least one independent director is present. So even in these kind of questions, what you can do here, you can simply apply the logic as well, right? So based on your reading, you can simply apply the logic, and believe me, when you apply the logic, you can definitely eliminate 2-3 options, right? That is definitely, you can eliminate 2-3 options, and this is the win only if you are, if the question which you are not confident in, so even if you are eliminating 2-3 options, so that is a win only, that is a victory only, right? Yes, guys, tell me. So right answer is option number E, that is at least one independent director is present here. So the proviso to section 173 subsection 3 allows board meeting to be called at a shorter notice to transact urgent business, provided at least one independent director, if any, is present. Yes, Rohit, you have given the right answer. Question number 5, if no independent director is present at a board meeting held at a shorter notice, the decision taken shall become final only after, options are approval of shareholders, ratification by at least one independent director, filing with the registrar, confirmation by the chairperson, or approval of the audit committee. Yes, guys, do let me know. What is the right answer? So right answer will be option number B, that is ratification by at least one independent director. So where a board meeting is held at a shorter notice without the presence of an independent director, what we have seen, that board meeting can be held with a shorter notice, but the thing is at least one independent director must be present. But suppose if board meeting is held at shorter notice and no independent director is present, then in that case, as per section 173 subsection 3 requires that decision taken must be circulated to all directors and shall become final only upon ratification by at least one independent director. So that decision which has been taken in the board meeting, that must be later on ratified by at least one independent director, right? So that is why option number B is the right answer. Question number 6. Guys, my humble request is please mention the question number as well in the chat box. Question number 6 is, under section 173 subsection 5 of the Companies Act 2013, which companies are deemed to have complied with board meetings requirement if they hold at least one board meeting in each half of a calendar year? Options are all public companies, listed companies only, government companies, one person company, small company, endowment company, or private companies with paid up capital below 1 crore. So tell me, read the question carefully. Do let me know what is the right answer here. So right answer is option number D, that is one person company, small company, and dormant company. So for these company, there is a special provision. Basically, even if they are conducting the board meeting, we have covered the board meeting requirements that in a year, basically 4 board meetings must be conducted. But for one person company, small company, and dormant company, there is a provision if they are conducting at least one board meeting in each half of a calendar year, so it will be considered that they have complied the board meeting requirements provision. Got it? So section 173 subsection 5 provides a relaxation from the general board meeting requirements to one person company, small companies, and dormant company. These companies are deemed to have complied with the law if they conduct at least one board meeting in each half of calendar year instead of the usual minimum of 4 meetings. Got it? Question number 7th is, as per section 173 subsection 5 of the Companies Act, the minimum gap required between two board meetings for a one person company or a small company is 30 days, 60 days, 90 days, 120 days or 180 days. Guys, those who are participating in the session, they are basically showing that how much they are serious about their examination, right? If you are simply here to listen the question and answer, this is not going to help you a lot. If you are participating, if you are committing mistakes, believe me, this is going to be a game changer in your preparation. Got it? And this you will realize little later when exam would be approaching. So do participate. Do not wait for the right answer. जस्ट पार्टिसिपेट, कमिट द मिस्टेक्स, ठीक है? जितनी ज्यादा मिस्टेक्स आप यहाँ पे करेंगे उतनी ही कम मिस्टेक्स यू विल बी कमिटिंग इन द एक्चुअल एग्जामिनेशन. सो नाउ चॉइस इज योर्स वेदर यू वांट टू स्टे साइलेंट हियर और यू कैन बेसिकली एग्जाम में आप अच्छा करना चाहते हैं, एग्जाम में आप बहुत ज्यादा मिस्टेक्स कमिट करना चाहते हैं, दैट इज अप टू यू. यस, सो अंकित इज सेइंग ऑप्शन नंबर ई. सो राइट आंसर इज ऑप्शन नंबर सी, नॉट द ई, दैट इज 90 days here, right? So according to section 173 subsection 5, while OPCs, small companies and dormant companies are required to hold any two board meetings in a year, the law mandates that gap between these two meetings must not be less than 90 days. Question number 8 is, as per section 174 subsection 1 of the Companies Act 2013, the quorum for a meeting of the board of directors is, options are 1/4 of a total strength or 3 directors, whichever is higher, 1/3 of total strength or 2 directors, whichever is higher, 1/3 of total strength or 3 directors, whichever is lower, 2/3 of the total strength only, or all directors of the company. So tell me, quorum, we are talking about the quorum for the meeting of board of directors. What is the meaning of quorum? Quorum is the minimum strength required to conduct the meeting successfully, right? So you have to tell me what is the quorum for a meeting of the board of directors. Yes, Rohit, you will get the PDF, right? But for that you have to join my Telegram group. The link I will be sharing at the end of the session. But only PDF I will provide to those who would be participating in the session. So PDF will be given to them only. And personally, I would be sharing on my Telegram group to the persons who would be participating in the session. So Rohit is saying option number B. So option number B is the right answer. That is 1/3 of total strength or 2 directors, whichever is higher. So as per section 174 subsection 1 of the Companies Act lays down a minimum quorum requirement to ensure that board decisions are taken with adequate participation. The law prescribes that quorum shall be 1/3 of the total strength of board or 2 directors, whichever is higher. Question number 9 is, for the purpose of quorum under section 174 subsection 1, participation of directors through video conferencing, options are, shall be counted for quorum purposes, shall not be counted for quorum, is allowed only with prior approval of the chairperson, is permitted only in an emergency meetings, or is allowed only for independent directors. Tell me, so if any director is participating through the video conferencing, so what will be the status of that participation? This is the question here. Yes, guys, if you want PDF of this session, you need to participate in the session in the chat box. Those who would be participating, I will be personally sharing the PDF to them over the Telegram group, right? So now choice is yours. If you want PDF, so do participate. If not, then you can stay silent and you can simply listen MCQs here. So right answer is option number A, that is shall be counted for quorum purposes. So if any director is participating through video conferencing, so it shall be counted for quorum purposes, right? So you have to keep in mind. The Companies Act 2013 expressly recognizes modern modes of participation under section 174 subsection 1. Directors participating in board meeting through video conferencing or other video audio visual means are counted for determining quorum. Question number 10 is, a resolution by circulation is deemed to be duly passed only when it is approved by which of the following? Options are, all the directors of the company, at least 1/3 of the directors, a majority of directors entitled to vote, the chairperson alone, or only independent directors. Guys, these kind of questions would be asked in the examination, right? So that is why I am taking these questions in the class, in these sessions. Tell me, question number 10, what can be the right answer here? Even if you do not know, make a guess here, apply the logic based on your reading. Try to apply the logic. You will definitely eliminate some of the options and the task will be easy for you. So right answer is option number C, that is a majority of directors entitled to vote. So as per section 175 subsection 1, a resolution passed by circulation is valid only if it is circulated in draft form, draft form along with necessary papers to all directors at their registered address and is approved by majority of directors entitled to vote. Question number 11th is, if not less than one third of total number of directors require that a resolution by circulation be decided at a meeting, the resolution shall be, options are automatically cancelled, approved only by written consent, referred to the registrar, placed before a meeting of the board, or deferred indefinitely. Friends, please do mention the question number as well. I'm requesting you because I would get confused that which question you are mentioning here, which question you are attempting here. So it's my humble request, before attempting, do mention the question number. So tell me the right answer for question number 11th. So right answer will be option number D, that is placed before a meeting of the board. So the proviso to section 175 subsection 1 safeguards participative decision making by allowing directors to demand discussion if at least one third of the total directors insist that a circulated resolution be decided at a meeting. The chairperson is mandatorily required to place it before a duly convened board meeting. Question number 12 is, according to Section 176 of the Companies Act 2013, acts done by a person acting as a director shall, options are, be invalid if his appointment letter is later found defective, remain valid despite defects or disqualification in an appointment, be valid only if approved by shareholders, be void unless ratified by the board, or be valid only till defect is discovered. Yes, everyone, do let me know question number 12th. Please mention the question number, guys. So Ankit is saying option number B. Ankit, please mention the question number. Yes, friends, everyone, do participate. Do let me know. What do you think? What can be the right answer? So right answer can be option number B. That is, it remain valid despite defects or disqualification in appointment. So any act done by a person acting as a director, later on if it is found that the appointment was defective, or the director was basically facing disqualification, it doesn't matter. Whatever action he has taken, basically that will remain valid. And hence option number B is the right answer. So section 176 of the Companies Act 2013 provides that acts performed by person acting as a director shall not be invalidated merely because his appointment was later found to be defective, disqualified, or terminated under the act or the company's articles. Question number 13th is, the provision relating to the audit committee under the Companies Act 2013 is contained in which of the following section of the Companies Act? Options are section 173, 174, 175, 176, or 177. Guys, sections are also very important. Section number, the important sections you must remember, because few questions, 2-3 questions you might find in the examination related to section number, right? So this is one of the section which is important. That is the section number of the audit committee. So tell me, what is the right answer? Please go through the previous paper so that we will get to know what kind of questions are basically asked in the examination. So one such category is the section number. Though you may not find many questions from the section number, but the thing is that few questions you might definitely get, 2 or 3 questions you might definitely get from the section number category. So Ankit is saying option number E. Okay, Rohit is saying option number B, but the right answer is option number E, that is section 177, right? So section 177 is related to the audit committee. So section 177 of the Companies Act 2013 deals with the constitution, composition, and functions of the audit committee. Got it? Question number 14th is, as per section 177 subsection 2 of the Companies Act 2013, the audit committee of a company shall consist of which of the following options are at least 3 directors with independent directors forming a majority, only executive directors, at least 2 directors with no requirement of independence, all directors being independent directors, only nominee directors of financial institutions. So according to you, what can be the correct explanation here? The composition of the audit committee we are discussing here under section 177 subsection 2. So let me know, guys, what do you think? What can be the correct explanation? Everyone, mention the question number in the chat box and do mention your options, which options you feel that this is correct. Okay, so Ankit is saying option number A. Okay, Rohit is saying option number C. Yes, guys, what about others? This session is not conducted only for Ankit and Rohit. This session is conducted for everyone, right? So you all have to participate. So right answer is option number A only, that is at least 3 directors with independent directors forming a majority. So this is the correct one. So yes, Ankit, you have attempted it correctly. But Rohit, hats off. You keep attempting the question. That is a good thing. So section 177 subsection 2 of the Companies Act mandates that the audit committee must have a minimum of 3 directors, and importantly independent directors must constitute the majority of the committee, right? Question number 15th is, if a transaction up to rupees 1 crore is entered into by director without audit committee approval and is not ratified, the transaction shall be, options are automatically valid, voidable at the option of the audit committee, void ab initio, deemed approved by shareholders, or valid subject to a board approval. Definitely, Rohit. You have to make the revision. Do make a revision. Revision is very, very important, right? Until and unless we revise the things, we are not able to retain it for longer period of time, right? So yes, revision is important, and these sessions are one of the mode through which you can revise the concepts, right? So इसीलिए these sessions are important so that you can make the revision, you can gain the confidence, you can enhance your knowledge, you can commit the mistakes. So for all these purposes, these sessions are conducted, right? So that is why these sessions are very, very important. So do not underestimate the importance of these sessions. They are very, very important. They will help you to revise the things as well. Ankit is saying option number B. Okay. Yes, guys, everyone, you all have to participate, right? There is no option. There is no exception there. Everyone have to participate. And those who would be participating, I told you, I will give the PDF to them, right? Personally over the Telegram group. So if you want the PDF, you need to participate. If not, then it's okay. You can simply listen here. So right answer is option number B. Yes, correctly. It is voidable at the option of the audit committee. Yes, very well done, Ankit. You have attempted it correctly. So explanation to question number 15th is, as per proviso to section 177, if a director or officer enters into transaction involving an amount not exceeding 1 crore without prior approval of the audit committee, such transaction must be ratified. Question number 16th, within what period must an unauthorized transaction be ratified by the audit committee to remain valid? Options are 1 month, 45 days, 2 months, 3 months from the date of transaction, or 6 months. Yes, this is related to the previous question only. So let me know, within what period must an unauthorized transaction be ratified by the audit committee to remain valid? So right answer is option number D, that is 3 months from the date of transaction. So the law clearly provides a 3-month window from the date of transaction for the audit committee to ratify a transaction entered without its approval. So if approval is not taken from the audit committee, that we have discussed in the previous question, if approval is not taken from the audit committee, then there is a window of 3 months open with the audit committee. So in this window of 3 months, if audit committee ratifies, then in that case, that basically that transaction will be becoming the justified one. Got it? Question number 17th is, if such an unauthorized transaction involves a related party of a director, who shall indemnify the company for any loss? If any loss occurs and which involves unauthorized transaction in a related, through a related party of a director, so who will be indemnifying the company for any loss? Options are director concerned, audit committee, board of directors, the company itself, or the related party only. Yes, friends, do let me know what can be the right answer according to you. Question number 17th. So right answer is option number A, that is the director concerned. So director concerned shall be basically liable to indemnify the company if any loss occurs there in the case of unauthorized transaction uh, involving a related party of a director. Got it? Yes. So Ankit has given a right answer. Very well attempted, Ankit. Question number 18th is, under section 180 subsection 1 clause A of the Companies Act 2013, the board of directors can sell or dispose of whole or substantially the whole of any undertaking only with, options are approval of the audit committee, approval of the registrar of companies, approval of the central government, ordinary resolution passed by the company, or consent of the company by a special resolution. Yes, guys, let me know. What do you feel? What can be the correct explanation here? So right answer is option number E, that is consent of the company by a special resolution. So section 180 subsection 1 clause A places statutory restriction on the powers of board by requiring shareholder approval through special resolution before selling, leasing or otherwise disposing of the whole or substantially the whole of the company's undertaking, right? Question number 19 is under section 186 subsection 2 of the Companies Act 2013, a company shall not give loans, guarantees, securities or acquire securities exceeding which of the following limits. Options are 50% of paid up capital and free reserves, 75% of free reserves and securities premium, 100% of paid up share capital, 60% of the paid up share capital, free reserves and securities premium, or 100% of free reserves and securities premium, whichever is more, any limit as decided by the board. So read the question carefully. उसके बाद do let me know. So right answer is option number D, that is 60% of the paid up share capital, free reserves and securities premium, or 100% of free reserves and securities premium, whichever is more. Got it? So section 186 subsection 2 places a quantitative restriction on a company's financial exposure through loans, guarantees or securities or investment. The company cannot exceed 60% of its paid up share capital, free reserves and securities premium account, or 100% of its free reserve and securities premium account, whichever is higher, without following additional compliance. Yes. So Ankit, you have attempted it correctly. Question number 20th is when the aggregate of loans, investments, guarantees or securities exceeds the limits, that the limit that we have just discussed prescribed under section 186 subsection 2, the company can proceed further only after obtaining, options are approval of the audit committee, prior authorization by a special resolution in a general meeting, approval of the registrar of companies, consent of all directors or approval of the central government. So what is the right answer? Right answer is option number B, that is prior authorization by a special resolution in a general meeting. So as per section 186 subsection 3 of the Companies Act 2013, if the total amount of loans, investment, guarantees or securities already made and those proposed to be made exceed the statutory limit laid down in section 186 subsection 2, then the board cannot act on its own. In such cases, the company must obtain prior approval of the shareholders through a special resolution passed in the general meeting. So yes, Ankit, again you have attempted it correctly, right? So guys, these all are the 20 questions that I wanted to discuss with you. But यहाँ पे if you want to see your name in the next session, like I have shown the name of Omkar Jadhav today because he has attempted the achievers question of previous session correctly. Now, if you want to see your name in the tomorrow session, you need to attempt it correctly. This is the homework question, and the question you are not supposed to attempt in the live chat box. You have to attempt in the comment box itself. So question is under section 186 subsection 5 of the Companies Act 2013. A company cannot make any investment or give loan, guarantee or security unless, options are, the board passes a resolution at its annual general meeting, prior approval of the shareholders is obtained, the company's articles specifically allow it, the resolution is passed at the board meeting with the consent of all directors present and prior approval of any public financial institutions with a subsisting term and loan, SEBI approval is obtained, right? So right answer you are not supposed to give here, you have to give in the comment box, not in the live chat box. And if you would be giving the right answer, your name will be reflected in tomorrow's session. Got it? So guys, this is all. And you know that if you are preparing for SEBI grade examination, and even if you haven't started the preparation, or if you have started the preparation but वो बहुत अच्छी नहीं चल रही, so you can join our crash course जहाँ पे सारी चीजें आपको dedicated way मिलेंगी, live classes, right, MCQs, mock test, one-to-one mentorship, each and everything you would get in a very you can say very organized format, so that you can prepare for this examination. Yes, you can still prepare for this examination because phase 1 is going to held on 10th of January, जिसके लिए आपके पास अभी है 23-24 days हैं. Basically phase 2 is the main game here, where which is conducted which will be conducted on 21st of February. उसके लिए आपके पास यहाँ पर टाइम है अभी, ठीक है? So this is the golden opportunity which you should avail, guys. So link is given in the description. You can go to the link and you can see what we are offering here. Separately आप यहाँ पे भी कर सकते हैं कि separately आप यहाँ पर हमारे वेबसाइट पर भी विजिट कर सकते हैं. Like I am showing you, what you have to do, you have to simply open the Google में जाकर टेक्स्ट बुक टाइप करिए, वहाँ पे फर्स्ट नंबर का लिंक आपको दिखेगा, ठीक है? उस पर जाइए then you can see the option of super coaching here at the top. Click on it. After that you can see left hand side पे आपको बहुत सारे यहाँ पे एग्जाम्स के नेम दिखेंगे. You have to click on the regulatory body exams. After that you have even if you are preparing for सेबी, आप सिर्फ और सिर्फ सेबी दे रहे हैं, then go for the सेबी कोर्स. यहाँ पे सेबी का हमारे पास डेडिकेटेड कोर्स है, like you can see सेबी ग्रेड ए 2025 जनरल एंड लीगल स्ट्रीम. But if you want to prepare for other exams also, which you should prepare in the regulatory domain, because there is a huge overlap of the syllabus, like RBI, SEBI, NABARD, PFRD, SIDBI, IFSC, IRDI, IFSCA, NPS, ECGC, इन सारे एग्जाम्स की प्रिपरेशन अगर आप कर रहे हैं, जो कि करना चाहिए बिकॉज देयर इज अ ह्यूज ओवरलैप, देन गो फॉर द रेगुलेटरी बॉडी एग्जाम सुपर पैक. यू आर नॉट सपोज टू have separate courses for separate examinations. Simply go for the regulatory body exam super pack. यहाँ पर जाने के बाद you have to scroll it down. आपको इसको scroll करना है, ठीक है. You will see all the related information here. You can see the faculties, you can see the demo classes as well. Then you can go through the e-books, the kind of notes that we are providing, then practice questions. After that, if you feel that yes, this course is going to help me, then you can enroll for the course itself. Different validity is available: 24 months, 12 months, 6 months. So you have to enroll according to your requirement. Suppose if you are applying, if you are basically subscribing for 12 months, what you have to do, you can see यहाँ पे this is the price, but this price you are not supposed to pay. You have to apply the coupon. यहाँ पे apply the coupon. First of all click on coupon, apply coupon में उस पे जो भी code applied है उसको remove कर दीजिए, and after that apply the code Prakash, PRAKASH. apply the code Prakash, and after applying it, what you have to do, आपको यहाँ पे अप्लाई करना है, एंड इंस्टेंट यू कैन सी मैक्सिमम डिस्काउंट आपको इंस्टेंट यहीं पर मिल गया, ठीक है. तो यहाँ पर इसके बाद यू कैन एनरोल फॉर इट. सो इवन यू कैन पे EMIs और यू कैन हैव अ फुल पेमेंट ऑल्सो, जो भी आप करना चाहें. इस तरीके से आप अपनी प्रिपरेशन यहाँ पे कर सकते हैं. अभी भी लेट नहीं हुआ है. आई वुड लाइक टू रिपीट इट अगेन, अभी भी लेट नहीं हुआ है. इफ यू आर सीरियस स्टूडेंट फॉर सेबी एग्जामिनेशन गाइस, यू कैन स्टार्ट प्रिपरेशन अभी भी, ठीक है. तो हमारे सुपर पैक के साथ जुड़िए, या तो फिर आप डेडिकेटेड सेबी ग्रेड ए का जनरल जो हमारा कोर्स है, जनरल और लीगल स्ट्रीम का, उस पर भी आप जा सकते हैं, ठीक है. तो दैट इज चॉइस इज योर्स गाइस. सो डू नॉट फॉरगेट टू अप्लाई द कोड प्रकाश, थ्रू विच यू विल गेट द मैक्सिमम डिस्काउंट. एंड दिस इज माई टेलीग्राम ग्रुप, डू ज्वाइन इट. इसको स्कैन करके ज्वाइन कर लीजिए. इसको ज्वाइन करने के बाद आप मुझसे टच में रहेंगे. जो भी क्वेरीज, जो भी इश्यूज हैं, दैट यू कैन बेसिकली डिस्कस विथ मी ओवर दिस टेलीग्राम ग्रुप. इसको आप यहाँ पे चेक कर लीजिएगा, ठीक है जी. और PDF भी आपको वहीं पर मिल जाएगा. आप मुझे पिंग करेंगे वहाँ पर PDF, आई विल शेयर इट. एंड फर्दर इफ यू फेस एनी काइंड ऑफ डिफिकल्टी, यू कैन आस्क मी ओवर देयर, ठीक है. दिस ग्रुप इज एक्टिव 24/7, सो यू कैन रेज योर क्वेरी एनी टाइम. So guys, this is all. Thank you very much. I hope you enjoyed the discussion. We'll meet tomorrow at the same time, but do not forget to attempt the achievers question if you want